afternoon, everyone. My name is Jason Marks. I am the Chair of the Board of Ethics and Campaign Practices, and I'm calling to order the Commission's scheduled notice meeting for April 27, 2026. It's 1:03 p.m. We're starting just a couple minutes late. Our second item, we let the record reflect, we have a quorum. We have myself, we have Mr. Kelly, we have Ms. Mr. Kunev, Ms. Sullivan.
Jason, is your mic on? Just to make sure.
Is it not? Can you hear me?
There we go.
Let's do this here. Our next item of business is review and approval of the agenda for today's meeting. If there are no executive session, is that to approve the agenda as presented?
I will so move.
Thank you, Ms. Cameron. Second, Mr. Kunev, seconds. All in favor, signify by saying aye. Aye. Opposed, none opposed. Next, we have review and approval of the minutes from January 14th, 2026. Any changes or discussion? Hearing none, is there a motion to approve as presented?
I will so move.
Second. The second by Mr. Kelly, moved by Ms. Caffrey. All in favor, signify by saying aye. Opposed, say nay. Unanimous, pass. Okay. Now we have a discussion item, and this is I guess we're going to get a report on the district court lawsuit, Center for Civic Action versus City of Albuquerque Board of Ethics. Is it Mr. Jackson's going to present? We may go into closed session. Let's get started and tell us what you're going to talk to us about and figure out what to do.
Chair Marks, this this is a lawsuit that was brought by certain organizations against the City of Albuquerque related to some of the campaign finance disclosure laws that the council has passed promulgated rules, and with which the board is part of enforcing. There's a preliminary injunction in place, and we had hoped to advise the board on status and strategy of closed session.
Okay, so sounds reasonable. And this is the lawsuit where a large part of the Measure Finance Committee reporting requirements were deemed to be unconstitutional by federal district court, correct? And there have been, and reported to us on this in the fall, and there have been some developments.
That is correct.
Okay. Well, it's certainly lawful for us to move into closed session pursuant to the Open Meetings Act, the exception at section 1015(1)(h)(7) to discuss pending and ongoing litigation that's covered by attorney-client privilege. The board is definitely a party, so if it's the pleasure of the board, we can go into a closed session and we will be done in motion and call votes. Ms. Sullivan moved. No, I read enough. I stated enough that the motion was covered. I realized it was a scrap. Is there a second? Second. You please call the roll.
Member Caffrey,
Yeah.
Member Kunev,
Yes.
Member Kelly,
Yes.
Member Sullivan,
Yes.
Chair Marks.
Yes.
I have the side room available.
How long do you think?
It shouldn't take long. I would say, 15 or 20 minutes to be outside.
Okay. We'll try to keep it to 15 minutes then. I apologize to the audience, but. While we were in closed session, the only matter that was discussed was the CCA versus City of Albuquerque lawsuit and council's proposal on the course of action. In closed session, there at the end, there was a motion from the staff by Mr. King to return to open session, which was unanimous, but we will not on the record. I'll ask for the same motion in second. The second we go again. That was being and I think you weren't on the record as here when we started, so let the record reflect that King joined us to close. Okay. Roll call for this or roll call vote on Pat Duffin.
Member Caffrey?
Yes.
Member Cuniff?
Yes.
Member King? Member Kelly? Member Selvin? Chair Marks?
Aye. And then is there a motion from the board for the member regarding the proposal that Mr. Jackson made? I move that authorize Mr. Jackson to settlement discussion as discussed. And authorize if he can, make a friendly amendment that, he's authorized to settle our behalf on the terms that were discussed. Second with that,
I'll second.
and let's just do a roll call on that one.
Okay. Member Caffrey?
Yes.
Member Cuniff?
Yes.
Member King?
Yes.
Member Kelly? Member Selvin? Chair Marks?
Aye, thank you. Item 4, discussion and potential action on complaint 0, excuse me. Item 5, city clerk's presentation regarding a possible investigation or further related to DOE complaint 11-2025, Eli versus unknown liquor finance authority. Mr. Watson.
Thank you, Mr. Marks, members of the board. As the board may recall, there was a complaint for the board late last year involving the yellow sweatshirts that was handing out on Central. There was one complaint filed against, I believe, Paul Guessing. There was a second complaint filed against an amendment finance committee. The complainant, I believe, stated in his presentation for the board that he was not in a position that because he didn't have a subpoena power, he could not proceed. The board at that meeting then discussed whether to commission or initiate its own investigation into the matter, and asked my office to request essentially a quote on what that would cost. And I reached out to Robert Caswell Investigations, who is on contract with the city to do a variety of types of investigations. He has now provided us a quote, which is right before the start of the second tab in your binders. His quote estimates that he would take around $6,000, and he outlines the work that he would take on the backside of his quote. He would review the relevant social media and digital material, conduct some fact-finding investigation, and then provide a written report to the board. I think his quote is clear. I think the question at this point is whether the board is proceeding with that or ask someone else to see if having to do that, but then it's fine before the board.
Questions for the clerk? I am, I move that for and for motion, is there a second? I'll second for discussion. Second. Mr. Watson. Where's the money gonna come from?
If the board elects to go forward, we will find funds to make this happen.
Clerk, clerk's office, right?
Yes, the board, we will address it through the budgetary process.
Members, any other discussion?
Would, would any reports by RCI public capital investigations be public?
I believe it would be public. Sorry, Mr. Chairman, Member Caffrey, I believe the report would be public when the board has had these investigations done in the past, they have been public. So for example, in 2021, a public report from the Inspector General's office. Type of thing.
And on that point, so we do have the inspector general, but was there any exploration of having the inspector general office do some kind of investigation?
I believe I reached, Mr. Chairman, Member Caffrey. I did discuss this briefly with the Inspector General's office, and my recollection was they did not have the capacity to do this at this time. I can certainly reach back out to them if you'd like to explore that, but my recollection, I apologize, the local time is passing, but my recollection is they did not have the capacity to do it.
Let's take a roll call vote on the motion, pending with this to, ask the clerk to engage RCI to conduct this investigation. I actually have a question. So, at some point, there's a statute of limitations on the complaint for possible action. When does that age out?
I would have to, I believe, without looking for it immediately, Mr. Chairman, there is a statute of limitations from 120 days from the violation, but there is an exception when the facts aren't known or we don't have the facts. And I think in this instance there is. We don't know. So I think the intent is to discover that. I will also say that I think that statute of limitations, the board's never disagreed with my thought of those saying that the statute of limitations only applies to complaints from the public and not necessarily the complaints the board's initiated, but
More likely than not, if there was actionable findings from the investigation, it's just a possibility.
Mr. Chairman, I'd be happy to research that and bring it forward on now during the meeting.
I don't see. I want to offer the filing is one place to Okay, with that, let's do a roll call and, we're not doing anything with the complaint, we're just reauthorizing the clerk to examine the investigation.
Member Caffrey,
No.
Member Kuna,
Yes.
Member King,
No.
Member Kelly,
No.
Member Selvin, Chair Marks.
No.
Fails on a 5-1.
Unless, unless any of the, members express an interest now in pursuing this through other means, we're gonna consider it closed, and I think we're gonna have to discuss the legalized complaint. Well, let's take that as another juncture. Mr. Eli can come back with his complaint. In theory, he could ask us to issue subpoenas. We'll prejudge that. So my initial thoughts will stand so that if the board has anything pursuing this independently of Mr. Eli prosecuting the complaint state now, or I think it's one of the four. Yeah. With that, we're gonna be on item 6, discussion and potential action on resolution 01/2026, which is to adopt the meeting schedule and public comment process Zoom meeting type. That is up here somewhere.
It is. So, Mr. Chairman, the report for the investigator, the 2 pages right before that in your binder. So looks like this. The sections that are changed from last year's resolution is highlighted. Very minimal changes. The location, making sure that if it's a hearing here in person is at Plaza del Sol. Also ensuring that if it's streamed, it's to YouTube. We now have a standardized link, so that will allow the public to find exactly where we are. This was made a little while ago, but my suggestions for the 2 dates were July 7th and October 6th. Although this would technically be our 2nd meeting of the year, and I think that's the only requirement is that we meet 2 times a year outside of an election. So theoretically, we would not need to meet again, but this resolution does add 2 dates.
And July 7th, I'm on a phone,
Okay.
which assuming they have, assuming they find jet fuel. Yeah,
Because it's just after a long, particularly raucous holiday weekend. Just wondering if everybody will be available.
how about July 14th? That change, and then if we have no business at all, we can, I'll cancel that meeting. And then October 6th, well, just for everyone, in case we need a meeting.
The full yes, that matters.
It's just,
Um,
okay. Okay. Any other changes?
The last section, Mr. Chairman, is the public comment, which is the backside of that paper. Just essentially follows what other boards and commissions do. Public comment would come to me or a certain person, and they would be able to be submitted before the board.
Okay. And we'll take comments on matters other than having to.
Correct.
We have a motion on the, open meetings, resolution, with the, date change.
I move to adopt the open meeting policy, schedule meetings with the things that we need on board.
Thanks, Captain. All in favor, say aye. Opposed? No opposed? Item 7, discussion and potential action on the annual report.
Mr. Chairman, this is still within a draft. I don't think it's prepared to share with the board. So I'd like to, if possible, defer it to the next meeting.
Okay, so we're down to July 14.
Correct.
Okay. Okay, that takes us to item 8, which is our evidentiary hearing on, Board of Elections complaint 10-2025. And that is, Candelaria versus, Ms. Garcia. And,
So before we get started, so I will be recusing myself from hearing this matter as, Mr. Candelaria represents me as a plaintiff in an Infraction Public Records Act lawsuit. Actually, a couple of them, not against the city, against other entities. So I will not be.
we for the record. Uh, let's start with appearances and then I'm going to give some introductory
Yeah.
remarks. And,
You need another one?
Yes. So
Just know the cameras are on the side.
you just have to do it. We got Brian.
And then whoever's speaking the most should use that. Very public. Yeah. Yeah, push that button down. Yeah, just one simple screen. That is it. If you don't hear it in the room, they'll hear it.
Who's appearing for complainant?
One more time.
Who's appearing for the complainant, Mr. Valaria?
Good afternoon, Chairman Marks, Devin Teriyaki, on behalf of complainant, Jacob Candelaria. And with me is co-counsel, Wilma Estes as well.
And, Ms. Garcia.
Evening, I'm appearing on behalf of respondent Teresa Garcia and Ms. Garcia present. Also, with us in the back is Attorney General Miro. In case I need to step, for the public comment in this. Okay.
So, the Albuquerque Elections Code makes the chair the presiding officer for hearings. I'll be controlling the proceedings and make rulings on procedural and evidentiary matters that arise if any. Members will be able to ask questions of the attorneys and witnesses at every juncture. And the final decision on the complaint is going to be by the board. But we're not normally going to take a vote on every objection from a party's attorney or even on preliminary motions. Keep things moving. You're just going to make a ruling. However, in this particular matter, it's possible I may make some rulings that will exclude testimony and/or exhibits. The board could disagree and believe that the testimony ought to be available to the board to make its final decision for the exhibits. For that reason, we will have the ability today for the board to overturn a ruling by the chair by a majority vote. If a member feels like I'm excluding something that they would like not excluded, a member may make a motion and it's seconded. The board may discuss the ruling and or ask the parties for argument, after which a vote will be taken. Parties may not request an appeal to the board. And this is basically, lesser included power. You have the power to replace me as the chair, so I'm giving you the power to overrule me on procedural stuff. But hopefully, because it's going to be our collective decision, but hoping to keep things moving. I'm going to allow opening statements of 4 minutes each and closing arguments of 6 minutes. Counsel complainant will go first. He may reserve some of his closing time. Bottom. Won't be any time limits on witness testimony and cross-examination. And I'm going to be pretty strict on imposing limits on the scope of testimony to exclude testimony on matters that are wholly outside of the court's jurisdiction. We will take exhibits individually, hopefully with some foundation from a sponsor and witness. Just to be clear, after some foundation from a witness, counsel will need to move the admission of the exhibit if counsel wants it to be considered in the record. Decisions and other documents from the underlying judicial cases are potentially admissible. I've seen Mr. Candelaria had some sections from the code and regs possibly. So the code, City of Albuquerque ordinances, charter material, regulations, those are not, those don't need to be offered as exhibits and won't be accepted as exhibits. But if you have paper copies and you want to use those as aids to making your argument to the board, you're welcome to distribute those. we had some pre-hearing and preliminary motions, we had some to, reschedule the hearing. And those have been obviously addressed well here today. There were a bunch of emails between the parties in this tribunal prior to the first continuance, arguing procedural and substantive matters and attending various claims and assertions. Parties were advised by me that it was not appropriate to argue their cases by emails and that these emails were not going to be part of the record as emails. Mr. Candelaria subsequently converted the email exchange to a PDF document posted as an exhibit, which is definitely more appropriate procedurally, although the material still might not be admissible to the record, and we'll come to that. For now, on the record today, I am reaffirming my ruling in the email to the parties that informal correspondence to the chair prior to the hearing on any matter other than scheduling is not part of the evidentiary record. Next, I have a motion to exclude and for a more definite statement from Mr. Candelaria. He sought to exclude the original pre-amendment complaint. My ruling is that the amendment complaint is the controlling document for the hearing and the ruling, but the original complaint is potentially admissible evidence for any matter that it was relevant to. However, it was not on Mr. Ring's original exhibit list, so I don't think it's maybe a moot question. Next, Mr. Candelaria sought to admit his exhibit with email exchanges. Is that in the book here somewhere, Ms. Rocha?
The email exchanges,
Yeah.
what was submitted is here, yes.
I think it's behind the complaint, isn't it?
Mr. Chair, one comment to make, well, actually, I need to inform the board, Deborah and I have come to an agreement that the motion, in limine and fine motion to exclude, we're going to stipulate to those, except for, the false statement allegation, they're just going to stipulate that it's incorrect facts. Is that,
I think in a little bit more depth, we'll stipulate that the hearing that was at issue there, in D-202 CV 2025-07791, overall did contain, nearly 7 hours in which many legal issues, were discussed that are ultimately controlling the judge's decision. But that ultimately, when the judge called Ms. Garcia's case, that was 15 minutes on the record specifically on her case. With the understanding there was about 7 hours before of discussion of legal issues, in the case of Ms. Reyes, which ultimately were relied upon by the court.
So, so as we get to the exhibit, you guys have come to a stipulation and the motions in limine. There's still, we didn't agree on completely on the false statements. I'm gonna tell you right now that it's my assessment that this case is about Ms. Garcia's campaign finance reports. And unless you consulted with Mr. Candelaria and he advised you on how to complete those reports, anything he says is not really relevant to the complaint. And this board has jurisdiction over his complaint, but we don't have jurisdiction over him as a person. I can't sanction him. I don't think there's any benefit to pursuing your allegation that he made false statements.
and that's what we basically stipulated to. I can't stipulate that there was a 7-hour hearing in Ms. Garcia's case because there wasn't. But I'm dropping the allegation that you made false statements and you should be sanctioned for them by dismissal. Okay.
I
Couldn't do that.
we could sanction that way, and I'm not going to.
I understand.
But it sounds like the disagreement over the statement was 15 minutes versus 7 hours, and sounds like you're both correct. In a sense, I mean, we're doing two different things.
Well,
Either way,
basically what we're trying to do is narrow the issues down to exactly what you said, which is Chris Garcia's campaign finance disclosures, rather than either attack on one attorney or the other.
Thank you. Very well, very well done. With that, we can move through things quickly then today. Uh, if there are no other preliminary matters, I'm gonna turn to, Ken Lawyer's side, Mr. Teriyaki.
Your Honor, we do have one more preliminary matter. We'd like to bring it to the board. Excuse me, Mr. Chairman.
Yeah.
So pursuant to the scheduling order that was issued on February 23rd, 2026, so there was an order to the respondent to bring copies of the representation agreement with counsel and of any other writings between her and counsel to prior to the date of the complaint that discusses billing or payment for legal services. Additionally, we did put in a request for an administrative subpoena for that scope of representation and fee agreement, as well as a copy of any billable hours report that breaks down specifically those hours, which I don't believe the attorney is going with.
So, yeah, thank you. I have like here, and I just skipped over. So, we did have a motion for subpoena. The first thing you, asked for was something that I asked for. They were directed to produce their representation agreement with counsel and or any other writings between her and counsel prior to the date of the complaint that discussed billing or payment for legal services. They did not produce anything like that, so we're going to presume that there is no such document.
Actually, I was instructed to bring it to here, so that's what I did.
Okay, you have one?
I have the original representation agreement. It sounds like the, dispute between the parties is what parts of the representation agreement are there. I researched this under the rules of professional conduct because this communication between me and my client, in some ways. But the fact of the fee that is relevant to the hearing, that is something that she has been willing to waive whatever confidentiality rights she may have. So I brought this so the board can make a determination as to whether they want the whole agreement or whether they want the first page. Because the first page describes the fee.
Well, let's do an in-camera review right in front of your eyes.
That's what I was gonna
Let's do that, and then I was just assuming that I made a mistaken assumption that we didn't put in this exhibit, we have one, so we'll look at that. And then as to the, I did not issue a subpoena for, hourly billing records. Mr. Candelaria side is welcome to examine, the witnesses on the other side as to their existence and what they have. And, we'll see where that takes us, but let's take a look at the representation agreement up here. Sure. And you may have that.
Your Honor, we would, Mr. Chairman, we would just want to register an objection that this was not produced, prior to today's hearing or.
That's on the record. Do you have more than one of these? No, sir, I don't know whether they were actually going to be admitted or not. Okay. And you would waive privilege on page one.
yes.
How about, it looks like item 3 continues to the top of page 2, costs.
Yeah, that's,
Waiting on that.
that's fine. In that section 2 as well, no cost.
Mr. Rocha?
Yes, sir. Yes, Chair.
Okay,
Would you like copies?
yeah, let's. Well. Might take a minute for upstairs copies. We can, yeah, I'm just trying to. This and this, take a look at this. This is what he's waving on. I'll represent to you that the rest of it is boilerplate, not specific to this engagement. It's usual stuff about client cooperating. Just from my own, when I was a practicing attorney, it's same stuff about no guarantee of results, client must cooperate, things like that. There are some references to financial matters after that, but they're mostly talking about the impact that strategies could have on fees. I don't think that the rest is really privileged, but it's not. It's in my rule. I think it'd be simpler just to take the first part that's undisputed, which goes to the matters in the complaint. Any board member want to see the whole thing?
It's not. It's just a. Yeah, Mr. Chairman, I think ultimately we wouldn't want to stipulate the exhaustive portion of the agreement being admitted. We ultimately feel the whole agreement is very relevant. We would want to see it admitted as there too. And ultimately, I mean, the whole dispute comes down to kind of basically this agreement as well there too. It's fairly inappropriate, I think, overall that the party's going to get a chance to review this agreement before the hearing today. We're having to take up the board's time and evaluating, portions of this. So,
Okay,
we move for the whole agreement.
all right. So let's do some duplication. Make 7 of the whole thing. Make 10 of just the first page, and this here, and so when those copies come back, we will. I'll make a ruling on the disputed remainder of the. When I have in front of me, yes, about the details, and then we'll make a ruling, but we'll put that in front of us. Do you think there'd be a problem with us taking the opening statements while we're getting duplication done?
I don't have a problem with that.
No, Mr. Chairman, I think that's fine.
Okay, let's do that then. Mr. Teriyaki? Am I saying your name right?
Mr. Teriyaki, yes, that's correct. I was gonna have a little timer going too, so.
Okay. Just, Mr. Roger, you able to help us with finding too?
Yes, sir.
Mr. Chairman, members of the board, thank you for your time today. So ultimately, this case really comes down to two big questions here. First, did Ms. Teresa Garcia violate sections 4D1 and 4D2 to the Albuquerque election ordinance when she failed to report these legal services that she retained from Mr. David Ring in connection to a lawsuit that was filed by a voter against Ms. Garcia in September of 2025, seeking a challenge to the sufficiency of those nominating petitions? And if so, shall the board issue a public reprimand or impose a fine for these violations there? Now, Mr. Chairman and members of the board, we feel this case is ultimately very clear. The Article 13 of Albuquerque City Charter creates the election code there. Now, Section 4D deals with reporting of expenditures there. Now, if we look at Section 4D, Mr. Chairman, Section 4D requires that the disclosure of every expenditure made on behalf of the campaign is reported in accordance with Section 4D2. Now, Section 4D2B7 specifically states that, long story short, basically any of the expenditures made in the month of September of 2025 must be reported by ultimately this Monday, October 13th of 2025 there. And pursuant to the election code, the board may issue rules that also govern how that happens there. So if we look at the rules for the election code issued there, and specifically what the definition of an expenditure is, which is contained in part 5, subsection B, it says, quote, an expenditure is made on the earlier of the date that the payment is made or on the date that consideration is received, if any. Now, that is really the key. It's the earlier of the two dates of whether it's payment made or consideration is received there. Now, Mr. Chairman and members of the board here, Ms. Garcia was a candidate for city council. She declared her candidacy for the 2025 general election there too. On September 2nd of 2025, the lawsuit was filed by this law firm challenging the sufficiency of those denominating petitions. Ms. Garcia was served with that lawsuit on the 4th of September. She retained Mr. Ring to provide legal defense of that, which resulted in a 52-page motion to dismiss being filed and ultimately a hearing in which the plaintiff agreed to voluntarily dismiss the lawsuit there against Ms. Garcia, which occurred on, again, September 12th of 2025. At that point, nothing else happens with the case. There's no more filing, there's no more pleadings. Effectively, the legal representation is done there. Now, Mr. Chairman and members of the board, ultimately our argument is regardless of when payment is ultimately tendered for those legal services, at the offset, there is absolutely an agreement in September when Ms. Garcia retains Mr. Ring that I promise to pay you some kind of money for these legal services there, and that Mr. Ring promises to provide those legal services in return. That is a textbook definition of consideration, and that is when it is received there. So based upon the rules here in the election code, it makes pretty clear that that is when the disclosure needs to take place. It's when the consideration is extended there too. And Mr. Chairman, if it was actually when the payment is made there too, this would allow candidates to be able to hide potentially legal representation retained or any vendor that they retain for campaign services simply by asking, don't send me an invoice until way after the election there too. So ultimately, Mr. Chairman and members of the board, we asked to find that Ms. Garcia did in fact violate sections 4D of the election code there when she failed to report the expenditures made from Mr. Ring's legal services. And we asked for both censure and fines, which can be issued under the rules that this board has done. And with that, happy to answer any questions. Thank you.
Kelly? Mr. Chairman, what was the? Is it your allegation that the legal services were completed by the end of that district court hearing?
Yes, yes,
Was
Mr.
that
Chairman.
date?
September 12th of 2025. That's when there's a notice of voluntary dismissal entered on the record by the plaintiff there. After that point, the case is effectively dead.
Well, that's your point.
Yeah, and there was no appeal made.
And you were going pretty fast through the election code here. What's the section where the date of expenditure is reported?
So I'm looking at section 4 of the election code, campaign financing, and specifically subsection D1C. It's D2B and then 7.
Are we in the boards, rule, or are we in?
And then the election code itself, Article 13 of the City Charter, election code, section 4. And Mr. Chairman, you'll see there's different subsections. A is one candidate, B is one bank account. D is disclosure of campaign financing. That's specifically the subsection we're looking at. There are additional subsections 1 and 2. That's in the rules, the rules for the city clerk for the election code, so a separate document that's promulgated pursuant to the election code. I'm happy to point out where that definition is as well.
And then just to stipulate for the opposing counsel, bring it out, please.
Mr. Kuriaki, the portion of the rules on definition is 2025 rule of law, which is city clerk, the election code, or looking at the full election code, the city charter.
That is correct.
Right, and it's part 5,
Part 5,
it's that for,
specifically Part 5B I mean, A and B are important, but Part B is saying when an expenditure is made.
and that is in the rules.
That's in the rules for the election code and the open ethical election code.
Okay, that makes sense. Mr. Ring, your opening? Yes, how much time do you have? Your preference. Okay. I won't be very long. This entire matter rests on, a narrow read of what consideration is, presented by an attorney in the course of its services, as well as what a candidate's obligations would be for reporting it if it were indeed an expenditure. The way this generally works, when you represent a candidate who's being challenged for an election nomination petition, is you enter an appearance on behalf of the candidate, and it's a public appearance. There's no, I don't know how a candidate would hide who's representing them when you're putting your name on pleadings in court, responding to media inquiries. It has several dimensions to it that are quite public. And so, Teresa Garcia was very publicly represented by an attorney by Occupy's Law in this matter. The reason why services, first off, services are not complete when you file a response, which is basically what they're saying. And then, like, if they decide to dismiss, which they ultimately did, there are additional issues that come into play later. Like, for instance, the fact that the court's order wasn't issued until February. The case is kept open, pending any appeals and whatnot. The other thing is the scope of this representation agreement covers appeals and ancillary matters. And ancillary matters are expected coming from, the Frank Canterbury law. The scope of the representation continued down the line because even if you win the legal battle, you may lose the political one. And so counsel continues to represent the candidate by advising her as to how to respond to statements made by Canterbury law and Canterbury himself in the journal, in social media, etc. So it depends on the scope of the agreement. I mean, the scope can be narrowed to just a particular, doesn't include the appeal, for instance, doesn't include any ancillary matters. In this matter, it did include those ancillary matters. Now, when an expenditure becomes reportable, is pretty much the only question before the board, and how it would be reportable in the absence of a bill. Is also because this board does have jurisdiction over candidates, but it certainly doesn't over attorneys and how they structure their fee agreements and how they get paid or if they. I certainly don't. Occupy's Law certainly doesn't do this for free, and in this case, there was a hybrid capped fee agreement. Now, as far as this capped fee agreement, you got to understand that when a candidate comes in and says, "Look, I'm being attacked by these people," or this attorney, or a combination of the two. What are you going to charge me? The answer is always, well, I don't know. It's very unpredictable matters. They tend to be very fluid depending on what the other side wants to do. In many cases, you're representing interests that have nothing to do with the success or failure of the campaign itself. It's just the legal issue of whether they should be on the ballot or not. So in other words, you can represent candidates without caring one way or another whether they have any chance of success with the campaign. So the fee is usually caps. Campaign managers typically want a predictable expenditure, and they can't just agree to an hourly fee agreement based on, you know, you just work hours and you bill, and we'll pay for them. That's generally not how this goes. Usually they ask for a capped fee, which results in what we call a hybrid fee agreement, where, you know, the fee is capped at a certain amount, but consideration has to be achieved at the end. There's no, you know, there were several maneuverings in this case and the related case, as far as notices of appeal filed.
Sounds like you're kind of giving testimony at this
Yeah.
point.
Yes, okay.
I'd rather take the testimony and argument.
Okay.
I think, Mr. Roach, you've been keeping time on this.
I missed this portion.
I think
Unfortunately.
I think you probably used your time. So
Okay,
I think
well, give me one more minute to sum up and.
just, yeah, give me the legal argument, because this stuff about how you came to your fee agreement with the client is more in the nature of evidence than argument.
Well, I'm saying.
Mr. Chairman, we would just object to the extension of the time there.
No, just wrap it up.
So, at any rate, a hybrid fee is not, the consideration isn't presented and the bill isn't due until the month. And that is basically, what, happens in these matters, not just, Ms. Garcia's case, but, almost all of them. So basically, if I agree to, if the lawyer agrees to fix a car, and he just gives you, you know, if you're required to come up with a fee before the consideration is before the fee, before the consideration is achieved, you'd just be handing them back a non-working car with a bucket of bolts. This case wasn't concluded until February of 2026. Yet it was reported in December at the end of the campaign. Because that is when we figured there's no more. I mean, so it depends on what you consider the beginning and the end of the case to be, and when the consideration is actually achieved and can be useful for the client. And that's the way it's done. This was checked with well, anyway,
Okay,
that's it. Thank you.
that's it, all right. Thank you. Now I got a little bit of time to look at the rest of the representation agreement. I'm going to admit as, overrule the claim of privilege as to pages 6 and 7, which was the date of execution. The material on pages 6 and 7 would give Mr. Candelari's team pages 6 and 7. The rest of it, I don't think it's particularly privileged, but it's also not relevant to any matter in this case. So I'm going to let Mr. Ring keep his oral point for us. So, and that has nothing to do with the matters of that issue here. The splash part shows the execution date and then also shows that Ms. Garcia agreed that if Mr. Ring brought another counsel, it would not change the fee. It's slightly relevant, but there's no references to anything having to do with payments. in the rest of the agreement. I stated, just not to invade their privacy. Without,
So is this gonna be exhibit one then?
Yeah, I was just gonna ask if it, you admit it or you still like to.
I'm waiving privilege on it, we'll admit it when we get there. So, Mr. Teriyaki, you wanna call a witness?
Yes, Mr. Chairman, complainant called Teresa Garcia. Just now.
Just pass through the line.
Please,
Mr. Chairman, is there a time limit?
no.
Okay.
No time on it, so
We'll keep this moving.
I don't think there's a lot of witnesses. We'll be open. Ms. Garcia, raise your right hand. Do you swear or affirm to tell the truth, understanding the first read under the laws of the state of New Mexico? Sound about right, everyone? It's been a while. Okay, Ms. Garcia, can you give your, name for the record, please?
Yes, that is.
And you're the respondent in the complaint?
Yes, I am.
Okay. Please proceed.
Thank you. Ms. Garcia, you were a candidate for city council District 3 in 2025.
Yes, it was.
And in order to register as a candidate, you have to file a declaration of candidacy.
Yes,
And by filing that declaration of candidacy, you're understanding that you're agreeing to abide by the rules of the election code. You understand that part of the rules entail regular reporting, contributions, and expenditures made by your campaign.
yes,
Now, Ms. Garcia, in September of 2025, you were served with a lawsuit, is that correct?
Yes.
And Mr. Chairman, permission to approach? The hand.
Yeah.
Complainant's document. Randy was in pre-marked for identification, complainant exhibit A. Do you recognize this document? Ms. Garcia?
yes. Yes, so.
And is that document in the same or substantially the same condition when you were served?
Yes,
In fact, this is a copy of the lawsuit that you were served with on the fourth one. Right?
Mr. Teriyaki, is this the document that's captured complaint challenging nominating petitions? And it's got a Bernalillo County, District Court stamp of September 2nd, 10:50 p.m.
Yes, Mr. Chairman.
Okay, so calling that A.
Yes, we move admission of with it.
This objection is to form, when the complaint be exhibit one.
Did you number yours with,
Yeah.
letters?
Yes, I did.
Would be okay if we do yours with, numbers, Teriyaki?
That's fine.
Okay. Thank you. So this is gonna be complainants one lawsuit. And it's a complaint.
Now, Ms. Garcia, you are named as a real party in this, right?
yes, that's right.
And when you were served with this lawsuit, tell me, what did you do in terms of getting it done?
I reached out to, a prior attorney to represent me in this case.
When did you first reach out?
As soon as I believe this. I started that in my house.
And did you have a meeting with Mr. Ring, phone call?
Yes, it was a phone call.
Now, without necessarily telling me the details of the substance of the discussion, was there a point during that meeting that you hire Mr. Ring as your attorney?
Yes, he said that he would consider it and, we would have another phone call conversation. We just needed to see if he had the time to represent her or not because of, the verification of addresses, just the work that it's gonna take, et cetera. And so like, there was like a little bit of.
Okay. When did he agree to represent you?
On the phone call, I remember the phone call, but we signed.
You referenced an agreement there, Ms. Garcia, you have a scope of representation agreement? Mr. Chairman, Commissioner approach? Yes. Provide a copy of this scope of representation agreement.
This council moving in submission.
I'm gonna lay some foundation and I will.
I prefer the nice.
Mr. Chairman,
Opportunity to pay one,
I
two,
was just
fifth. So I'm handing you.
I am handing you a copy of the scope of representation agreement that, given to Mr. Ring. Does this little, document look familiar to you?
Yes,
What is this document?
for representation.
And how do you recognize?
Mm-hmm.
How do you know that is the agreement? Though?
Because I signed it.
And is this, document the same condition as when you signed it?
Yes,
Mr. Chairman, move admission of, exhibit 2, the scope of representation.
No objection is submitted.
Now, Ms. Garcia, when you, when Mr. Ring agreed to provide legal, services for you, what were the terms of that, legal representation? For discussion of payment?
yes, there is, and it's indicated here on item 2, my break cap fee. There is a tiered, payment fees, which depending on the number of hours. Again, right, as you go into this, you don't know how many hours you're gonna need, it could be a lot of hours, it could be a little hours, so it's dependent, but, it has 3 tiers.
Ms. Garcia, ultimately though, by signing this agreement, you're agreeing to pay for legal services.
Correct.
Mr. Ring will, provide for you.
Yeah, and they're finalized.
The legal services were in connection with the lawsuit, filed against you, nominating petition.
That's part of it.
Did, Mr. Ring enter his appearance in that lawsuit for you following this agreement?
Yes, you did.
Now, Mr. Chairman, permission to approach. Garcia, I'm handing you a copy, of what's been pre-marked for identification as complainant's exhibit 3. Do you recognize this document?
Yes, you did.
What is this document?
And then it's. It reads as the Smith's. Involved resolution for some reason.
Ms. Garcia, this is in fact a copy of the motion that your lawyer filed on response to.
I believe something.
This document is the same condition and when you first saw
That looks something else.
it. Mr. Chairman, move admission of exhibit 3. Motion to dismiss.
No objection is submitted.
Ms. Garcia, were there any hearings that occurred in the lawsuit?
Yes,
Do you recall when that hearing occurred?
I don't remember the date, but there was a hearing. Maybe,
Was September 12th sound accurate of 2025? Were you present at that hearing?
yes, I-
Were you able to observe during all times during that hearing? Or were you able to observe the proceedings during all times of that hearing?
for before, right before the hearing.
Ms. Garcia, in the result of that hearing was a voluntary dismissal of the lawsuit against you. Is that correct? What was your understanding of leaving that?
That Mr. Bandalaya had decided to dismiss the hearing based on the judge's.
Did you understand for there to be anything else to happen with that lawsuit after the dismissal?
I didn't know if there was anything.
Did, Mr. Ring or yourself feel any other hearings following the dismissal voluntarily of that lawsuit on the 12th of September?
There were no other hearings.
Were there any other pleadings that were filed by Mr. Ring on your behalf?
No, there's-
Was there ever an appeal filed by the plaintiff in that matter?
Um,
Now, Ms. Garcia, would you agree with me that you hired Mr. Ring to basically dismiss this lawsuit against you?
yes, that was the basis of it.
And in exchange, you agreed to pay him the terms that were redefined in the representation agreement?
Correct.
And so, Ms. Garcia, when the lawsuit was ultimately voluntarily dismissed on September 12th, at that point, you received the benefit of that agreement. Tell me why.
Because, I mean, we're here today, it's still representation, right? I've also had, dealings with Mr. Jacob Benedetta, there was statements made, and so I still had, was seeking advice from counsel for those, different occasions, also threats on social media by Mr. Benedetta. And so, you know, pertaining to this representation, you know, there's certain out, you know, depending on the hours, there's different rates that I would be charged, and so because the hearing only lasted 10, 15 minutes, you know, there wasn't, I did not reach that amount, any amount, right, of hours for representation, and so we also, knowing Mr. Candelaria's, prior representation, right, it keeps going, there's a lot of appeals, there's a lot of paperwork, there's a lot of ongoing things, and that's exactly what happened in the regular day.
Ms. Garcia, I want to jump in. The dismissal of the lawsuit on September 12th ultimately was beneficial for you, is that correct?
It helps, yeah.
And Ms. Garcia, you understand that in that representation agreement, you agreed to pay Mr. Ring for legal services?
When they were finalized, yes,
You understand that that scope representation is an enforceable promise on your behalf to pay for those services?
which I did, yes.
So, but in fact, though, for example, say you would refuse to pay, that would be just something, Mr. Ring could bring a lawsuit.
Correct, for the party.
Yeah, that was an enforceable promise that you entered into by signing that scope of representation. Okay. Now, Ms. Garcia, you said testified earlier that you are familiar with the election code, the rules for the election code, the open code of the Free Charter. Is that correct?
Yes.
Mr. Chairman, permission to approach? Yes. Ms. Garcia, I'm handing you a copy of the rules for the election code there.
Okay.
Specifically, section 5. Can you see that okay?
Yes.
Now, section 5 details expenditure. Can you read for the record what section 5A says?
Definition of expenditure in addition to the definition of in section 2, an expenditure is a payment to produce a loan. A payment of a loan by a third party or an enforceable promise to make a payment, fee, and expenditure is made on the earlier of the date the payment is made or on the date of expiration, if any is received.
So, Ms. Garcia, I want to focus first on the section B that we just read, which said that the payment, either payment or consideration that's reported based on what we received. Would you agree this creates an obligation for you to report?
Yeah, and the consideration received.
Now, Ms. Garcia, you testified earlier though that you understood this agreement to be creating an enforceable promise for you to pay for the legal services?
Yeah.
And you understand that agreement also creates an enforceable promise that Mr. Ring will in fact provide those legal services for you? Now, Ms. Garcia, let me just take that document back. So, Ms. Garcia, under part 5, section 8-4, back to you. Do you see that an expenditure is in fact defined as a forcible promise to make a payment there?
I'm sorry, where?
The section, the part 1, section 4, there, definition of expenditures, one of them is forcible promise to make payment. Okay. Would you agree with me that in fact that is an expenditure defined in the rules?
I'm gonna object since it calls for a legal analysis, including Mr. Garcia, you an attorney?
No.
Do you have anything to say, Mr. Teriyaki?
I'll rephrase the question, Mr. Chairman.
It's a stand.
Ms. Garcia, based on your non-legal understanding there, just reading those words as a human being, does an enforceable promise to make a payment constitute an expenditure, the way you read that?
Can you say that again?
So without, just as a layperson, reading the actual words on the paper there, the agreement and expenditure is defined as enforceable promise.
Possible promise to make an agreement?
Yes. Our payment is due. Well, Ms. Garcia, let me move on here, so. Ultimately, you did pay for the services, correct?
Say that one more time.
You did ultimately render payment for the legal services?
Yes,
And that was based upon the services that were provided to you in September of 2025, correct?
in addition to other things that
But
is concluded yet.
Yeah, but there was legal services provided.
Teriyaki, when the witness is answering, let her finish and so the attorney. We done this. Garcia.
Thank you for that.
Ms. Garcia, though, correct me if I'm wrong, but we portion of that payment was for legal services that were provided by Mr. Lee in September of 2025.
Referring back to the agreement, right, it indicates
Yes.
the number, there's tiered, right, so depending on.
And Ms. Garcia,
Wait, Mr. Teriyaki. Please, let her finish.
Based on the number of hours, then I would owe a certain amount, right, so because the representation was reached, it was still in process and still, like, even after that hearing, I still had other, leftover hours that I could, work with reaching out to Dave, which I did end up doing, I just don't understand that kind of after the fact. Probably take it back.
now, Ms. Garcia, I really want to nail you down. Ultimately, those legal services you received in September of 2025, they were paid for by yourself, correct?
Right,
Now, Ms. Garcia, I want to back up now to the reporting, that you are required to provide the candidate for citizen council that. You understand you're supposed to provide regular reporting of expenditures made by your campaign there?
yes,
You understand that those are based upon different periods as prescribed by the rules?
yes.
Now, Commissioner approach, Mr. Chairman? Garcia, I'm handing you, what is the market volume exhibit 4? Do you recognize this document?
I don't recall it, but say yes.
Take your time with your roll, please.
Oh, got it, yes. Right, yes.
Mr. Garcia, for the record.
Yeah.
What is this document, for the record?
It is my campaign finance report that I filed on 10/14.
Document, the same or substantially the same condition as when you filed it?
Let's see.
Mr. Chairman, move the admission of exhibit 4, the campaign finance report.
There ain't no objection to it.
Okay. Now, Ms. Garcia, do you know what time period that this report, applies to?
The month before, so the month of September.
Okay, so this document, we report your expenditures made in the month of September, is that correct?
Correct.
Can you go through that document for us and circle it anywhere where you list Mr. Ring or his law firm services and expenditures that you made?
It will not be here.
In fact, you do not report those expenditure in the report.
No, I did not.
Mr. Rocha, we're having trouble finding that one. Put that in the folks.
Which document is this?
It's, time.
Yes, it's the one with the purple sticky. That's 7th campaign disclosure.
Okay. Mr. Teriyaki, we're looking at one that's called 7.
disclosure?
One more time, I'm sorry.
Number seven? It
Number,
says,
the seventh campaign finance report.
okay, all right. And that's. Then it. Continue, please.
Ms. Garcia, I want to direct your attention back to the representation unit. Are you introducing? You have that in front of you? On page 7, actually there, the name is Teresa Garcia and a signature above that. Is that in fact your name?
That is correct.
Is that your signature that appears?
Those are my initials. Oh, I'm sorry.
The final page there.
Yes.
And can you read the date that you signed this agreement? Now, Ms. Garcia, when you retained Mr. Ring, did you ask him at all to do in a way that was compliant with the election code?
Sorry.
When you retained Mr. Ring, was there ever any discussion you had with Mr.
Sorry.
Ring?
I'm gonna check based on attorney-client, privilege communication.
Attorney, might I respond?
Yeah.
Yeah, discussions between a client and their lawyer about payment details are pretty firmly not within attorney-client privilege. More substantive discussions about the actual merits of the defense there, but discussion of payment is not attorney-client privilege.
The fact of the payment, he's correct. The actual advice on the payment, no.
So. Question was, did you discuss? Did you discuss with Mr. Ring?
So when you retained Mr. Ring, did you ask him to bill you in a way that compliant with the election code?
Like,
Did you
if I
ask her
advised
your
her,
privilege if she's?
I'm mentioning about not the advice Mr. Ring provided, but
Yeah, so it's not your work product, but it's still to be privileged. Because it goes to,
whatever I'm advising her for her compliance, whatever I'm advising, whatever statements I make to her, and she makes to me regarding her compliance, with any codes or laws, that's really legally violated.
I'm gonna allow it as, I'm not gonna, on September 10th, I'm gonna allow her to answer whether she said anything to you about billing when you form a contract. I think thereafter, might be a different question as opposed to the ultimate issue in this case, and not sure where I am on that yet, but you can answer as to when you form the engagement, if you directed Mr. Ring to bill you in compliance with the elected code.
Yeah, it's basically,
She can answer.
okay,
I mean, after the hearing, there was still several hours that were pending, right? So like, I did ask, like, can you send me an invoice, right? Because I have to have an invoice in order to make a payment, right? I knew that, I tried to save as much as I could in my bank account to make sure that I had that money for when that invoice came in, but I mean, it just still, there were still other things that, it wasn't, the hours weren't done for me to pay, right, the 4,000 or the 6,000. So I just let him know, like, please invoice me as soon as you can, because I do have that. kind of-
Mr. Chairman, can I just object to that's not responsible?
Hold on, please. I'm restraining myself and we'll let her finish and all that. Are you done?
Yeah, I think that's what I heard.
Okay. Ms. Garcia, that was helpful, but it's not the question. The question was when you first engaged him, did you say, Mr. Ring, still be in conformance with the rules? At the time of the engagement, did you say?
I don't even,
Yes or no?
yeah, say no.
The answer is no.
Yeah. the answer is
Okay.
Notice no request that he bills in compliance with the monthly reporting deadline.
I mean, I probably did let him know that to invoice me at, as soon as possible, but not like,
Why didn't you specifically request that, he bill you in compliance with the monthly reports required?
because I still had hours to, right, like I was still waiting on like what that final amount was going to be. So if I don't have an invoice, how can I pay without having the final invoice?
Did you ever, request an invoice prior to filing your seven campaign report? Do you have a copy of that invoice available?
Not with me, no. But there is an invoice.
I'm sorry, I'm gonna object. This is, there's no foundation for he's asking. He changed his question from, did you request an invoice to, and she said, no, I believe, then now he's asking for the invoice that was sent. There's no foundation that an invoice was ever sent.
Okay, I re-ask the question. There's an invoice that's been produced to us, correct? And we've seen the invoice in this record, right? Mr. Lee?
Correct.
Not, hasn't been identified yet, but we've seen an invoice for $41,000, right? And $4,000 for GMC, right?
Yes.
Okay. And the question is there another invoice besides that one?
No.
Okay.
There's not. It's just the final invoice.
Okay, that's the invoice.
Ms. Garcia, was there anything stopping you from requesting an invoice every month?
I mean, other than being really busy with the campaign, but I don't really see that.
I'm gonna object to any hypotheticals as to what she may have possibly done. It's called for speculation.
Mr. Ring, what does a question pending and get this law? Mr. Teriyaki,
I'm sorry, Mr. Chairman.
your witness now.
Now, Ms. Garcia, back up to the time when you first retained Mr. Ring, between then and when the hearing occurred on September 12th, 2025, was there any, additional discussions you had with Mr. Ring regarding the case?
After the hearing,
You know, but between when you signed the agreement on September 10th and when the hearing occurred on September 12th?
was there communication between the hearing?
Yes.
Yes. There was.
Yeah, was there any work done between those two factors?
By his office, yes. To prepare for the hearing.
He's again objecting, calls for speculation. He's being asked to imagine facts that she doesn't personally know what kind of work I was doing or not doing.
Ms. Garcia, do you know or have reason to believe that Mr. Ring was doing work on your behalf between the 10th and 12th?
I mean, I would hope so. I mean, I would say yes, because there was, the motion to dismiss was produced, right? So that's work. So yes.
Ms. Garcia, prior to September 10th, after September 4th, when you were served the lawsuit, do you have any other discussions with Mr. Ring?
Other than reaching out to represent me.
Any kind of, and now following the hearing on September 12th, what other work was done in the case? What other work was done in that matter following the hearing where it was dismissed?
Yeah, so as I mentioned, right, there's other paperwork that needs to be done after the hearing because of the dismissal. I believe there was something that needed to be submitted to the court. And again, along that timeline, Mr. Candelaria at that time also did an op-ed for the journal. There was also social media threats towards me, that he would do a lawsuit against me for defamation because of speaking about the harm that was done by Mr. Jacob Candelaria, which I did a press release. Among other very harassing, abusive behaviors on social media. So I reached out to Mr. Ring on for advice on can I respond? Well, that's still work, right?
Overall, there's responsible, but Mr. Garcia, if you can avoid the characterizations, harassment, whatever, just kind of more dispassionate facts. There's been a lot of contention between these parties. You guys seem to have figured out that it's in everybody's interest to bring down the personal stuff. And let's just, you got me on that?
Yes.
But I am overruling this It is responsible, after whatever work he did for her when he's coming to, what would he do? She thinks he did.
Yes, I'm done.
So specifically with this loss, following dismissal on September 12th.
And then there was still paperwork to be done after I did hearing.
What paper?
After the dismissal, I guess there was like a response or something that needed to be submitted to the court.
Again, I'm just gonna object. It's not within her purview to practice as to what paperwork is going to be. Calling for speculation without her personal knowledge.
I think that's a good answer, what you know, if you don't know, it's okay to you don't know.
Any other hearing that you actually hear at following dismissal of the lawsuit?
At that time, no, but I mean, we were waiting for an appeal and we didn't know what was gonna come after that.
Did an appeal ever materialize?
No, it did not.
And so there are no other hearings before it's after the court.
That Stephanie Tay assisted, and so they kind of bunched both of us together, and so we were just kind of pending if I was gonna be included in that as well or not.
Ms. Garcia, are you aware that Mr. Granville only had 5 days following dismissal of that lawsuit to appeal?
I don't know the timing, I'm sorry.
Mr. Chairman, the rest of the case.
Mr. Ring, do you wanna, cross the witness?
Yes, I would, Your Honor. I mean, I can do it within the scope of, I can cross-examine within the scope of direct. But I would have to call her separately, so do you want me to do it?
What's your show for?
If there's no objection, I can do my direct as well as my cross.
Well,
I don't see,
That's not the one, either,
I'm sorry.
yeah, either you can do the whole thing when you call her as your witness, or you can do a cross now.
Oh, okay, I
I
see.
don't want you to do your direct now.
Okay, I guess I'll just do a little bit of cross. Maybe I just have about 8 questions.
Yeah, that one.
Mr. Chairman, I think we just want to be clear that if he's going to do cross-examination now, then when he calls Ms. Garcia as a witness, that calling would be restrained to just direct examination.
There's really not limits on that. I'm just trying not getting, if you've got a problem with something you asked him, he asks, well, we'll take it then, but I don't know the any limits on the, I don't know the questions and so forth, but, this is witness and I'm not going to the questions on cross either, so. You want to go within the scope of her direct now to, Mr. Teriyaki, and then you can have it later.
Okay, it was your testimony today that you did not, disclose, during your 7th campaign finance disclosure statement. When did you disclose the, attorney fee, cost law?
I believe it was in the January 8th campaign finance report.
Okay, and may I approach? And, should I just, I have 4 exhibits, would you like me just to approach and give them to, the chair, or just bring them up one at a time? It's always great, different bit.
The only thing about, do we have them in here, Mr. Winter?
His exhibits? Yes.
Yes, there's
They're under the,
anything, believe. But I don't want to mark them until they're accepted, obviously.
No, mark them.
Okay.
I mean, if they're not accepted, they'll have a wrap it up. They'll have a letter, but they won't be in there.
Copy of what I'm handing out. So I'm handing a document to the respondent witness, Teresa Garcia. Can you take a minute to look at that document and tell me what it is? This is marked as A. Yes, marked as respondent to exhibit A.
It is my, stating about the campaign by disclosure statement submitted on 1/8/2026.
Okay. And why do you recognize?
Because it's after the runoff,
You can submit it.
I did.
Okay, moving entry of exhibit A. There's no objection, if it's submitted. Um. So on this exhibit, can you please identify, where you disclosed the legal fees from off the cost law?
Yes. It's on page 6 of 8. The 5th line. For the runoff election in the amount of $4,244.
Okay. Now, directing your attention back to, the complaints exhibit 2, the representation of the agreement. Document entitled representation of the agreement. This has already been admitted, so I'm not, asking questions like the other attorney, but I did need to respond to. Why don't you, would you please read section 2, for the board?
Section 2 representation agreement hybrid capped fee. It is acknowledged that a retainer fee in the amount of $0 has been paid to attorney, and acknowledgement of the unpredictability of the scope of the work for cases involving election law and clients. Need for a predictable campaign expense. Attorney has agreed to take client's case on a hybrid hourly rate agreement up to the first 20 hours worked for a flat capped fee of $4,000 plus gross receipts tax. If 21 to 40 hours are worked by attorney, the flat fee due from client to attorney shall be 6,000 USD plus gross receipts tax. If the hours worked exceed 40 hours, the flat rate due from client to attorney shall increase to 8,000 USD plus gross receipts tax. Attorney may, but is not required to reduce fees for the services at the attorney's discretion.
Okay, and if you could also just, yeah, I think that's. So when Mr. Devrin, I'm sorry, Mr. Teriyaki asked you, a question, regarding whether it was discussed compliance with expenditures or campaign expenses, did you discuss that paragraph with your attorney?
Yes.
Okay, and also, you had said you contacted me with your attorney prior, in your prior testimony, you said you contacted me. Is it not true that Arkansas Law of New Mexico also represented Anna Martinez in your 2024 case?
Yes, that's correct.
Okay. Did you, so when was this agreement, in your own words, as a layman, when did you expect to report this expenditure and how?
I expected to report the expenditure when I received an invoice and I reached those hours of work.
Okay. In your, as a layman, when was the agreement completed? The representation agreement?
After the runoff election, is when I received the invoice, and so I paid it for the January.
Okay. Did you expect that even though, Mr. Jacob Candelaria had dismissed his lawsuit, he would file something subsequent to it?
No, I didn't, but the initial complaint, that he submitted was, rejected. And so then after that, I thought that that was done, but then after the runoff election, he resubmitted and amended, which resulted in this hearing.
Okay. When was the district court heard? I tell you what. Okay. I'm gonna place, what has been pre-labeled Exhibit B, responding to Exhibit B, before you. Can you tell me, what that document is?
This is the invoice, date billed 12/18/2025, for the amount of $4,244.
Okay, and, how do you, what's your knowledge of this document? When did you receive it? Okay.
I received it in December, and I, again, paid you, January for my campaign finance report on January.
Okay. And, did you then pay the amount due of $4,344?
This is it.
I'm gonna move the entry of the exhibit. Respond to exhibit B.
No objection.
Okay. Okay, you recall, you recalled already that you attended hearing, in the matter of, where you were the real party of interest. Can you, I just placed document, in front of you, the response to Exhibit C. Can you tell me what that document is? Will you recognize it?
I guess it's the time that the judge called the case. And then showing the ruling and then the recess, and then the date. Let's log of courtroom 6/16/9/12/2025.
Okay, so does this document accurately represent, the court record from September 12th, 2025?
I believe so, yes.
Okay, I'm gonna move the admission of respondent to Exhibit B.
Mr. Chairman, we object on the ground that not foundation's been laid. The witness did not testify she recognized this document, necessarily knew what it was, without any question to counsel talking about it.
Follow up.
It doesn't seem, Ms. Garcia, did you download this document?
No, I did not, but it looks like it's like a screenshot or like on New Mexico court or something, showing the time frame of,
Did you normally work with documents like this?
for my own personal pieces, it looks similar, yeah, indicates like who the party is.
Yeah, I'm gonna sustain the objection. I'm not gonna take this one, but you can ask the questions about the time.
Okay. Now that your memory's been refreshed again, what was your recollection of the length of that hearing?
I'm sorry?
How long was that hearing and what happened during it?
No, we just object to the witness being able to look at the document in front of her, she's testifying.
I mean, you guys talked about it for today's hearing. It's not a secret.
It was, I mean, I'm sorry, it was very quick, again, I think I mentioned it in my earlier testimony, like, it was kind of 15, 20 minutes, it was really quick.
Okay, was it your understanding that the dismissal may be contingent on the outcome of the other case with 7 days?
That's what I want.
the dismissal that was entered was contingent upon what would happen, the rulings in Stephanie Hayes' case.
Did I know that it was gonna be contingent?
Yes. Did you know that, okay, did you know that the two cases were related? With the finding?
Right, yeah, we were going to do this.
Okay. And so when it was dismissed, did you, pay attention to the appeal in Stephanie Hayes?
Hmm. No, because I wasn't there.
No, not the evidentiary hearing, the appeal, and what Mr. Candelario
Oh.
was after the two evidentiary hearings on September 12th.
Yes.
Okay. And did you expect that even though, Mr. Candelario dismissed his suit, that he would file something against you in any court?
I was under the assumption that, yeah, he probably would, so I just didn't know what
Okay.
he would do, but
And was it your understanding that until the judge entered a final order in the case, it's still pending?
yes.
Okay. I'm gonna place another document in front of you. This is gonna be, I guess, since the other one wasn't admitted, we're gonna label this one Respondents Exhibit C.
Towards people with D.
Oh, D,
Records
okay.
complexity is not admitted,
Okay,
and there's been stay at D since 1.5 years.
so Respondents Exhibit D. Take a minute and read this document.
Yeah, this is just the final order of the dismissal of the hearing that we had September.
Okay, you recognize this document?
Yes.
Okay. You, does this document, in your layman's understanding, is it termed the district court case?
Yes, it does.
Okay. And I'll move the admission of respondents to the, at this time.
No objection.
And D is admitted.
And, what is the date on this document? When was it dismissed?
So it looks like it was filed in second judicial district court, on February 2nd, 2026 at 3:10 p.m. by Christina Watson for the court action review for the September 12th, 2025 cycle.
Okay. So at that point, if the district court matter was over, in, with your understanding, the district court matter was over, was that the only matter that you retained Dr. Costello represented?
Yes. Well, with this case, yes, to represent me for this, right, this finalized the initial, but there was ongoing work hours that kind of.
Okay. Okay, and going back to, I think with the question, if we go back to the exhibit to, the representation agreement, that's been tendered by the complainant, the, Mr. Teriyaki was trying to, ask you questions regarding your understanding of the, nature of the consideration paid and whatnot. What is your layman's understanding of when you were to pay for this?
Reading this section again, like I mentioned prior, there's hours here that I pay for, or can go up to just depending on what we're gonna do for my case, depending on what that's, right? And so once it was finalized or I reached that, that's the number.
Okay, so when you received the bill, you paid it?
Right.
Were you waiting to receive the bill?
Yes.
Okay, open the question.
Do you have any redirect to this one?
Yes. What was that?
How much?
Yeah, maybe it's a handful, 5 to 6, I would say overall. Ms. Garcia, I just want to confirm the record here. So ultimately, you did disclose the expenditure made in the Ray's campaign, or to, for legal services?
Yes, we did.
It occurred after the election of the 25, correct?
After the runoff.
Now, Ms. Garcia, you have the scope representation agreement still in front of you?
Yes.
You tell support at one point that you do not expect to be paid, for your invoice.
I didn't expect to pay it until.
Now you have section 2 there in front of you. Can you point out anywhere in there that says, payment will not be able to receive an invoice? And now, Ms. Garcia, you did ultimately, pay Mr. Ring's, law firm over $4,000 of legal expense.
Yes, the 4,000 plus the groceries.
How much of that 4,000 was for legal services regarding, lawsuits that were pending for?
It's not people, so
We can put the exhibit in front of you.
Okay. Would you say that the bulk of that, more than 50%, less than 50% of that was for the legal services in September? Just in your own understanding, you're writing that check out to the store, that's clear. What are you thinking about those legal services paying for?
for the representation of the lawsuit.
That lawsuit in September 2025?
Yeah.
Now, in your own words, would you say more or less than 50% of that fee, in your own mind, is for specifically that September 2025 lawsuit?
I mean, I don't, there was other services rendered, right, because of the 20 hours. So I don't know
What other services rendered?
the advice that I requested, because the hours, the 20 hours were not completed in the hearing, the work for the hearing, so.
How many hours of advice did you receive following?
Well, they ultimately amounted to the hours indicated here for the 4,000.
Do you know how many hours, following the hearing that you received against Mr. Winston?
I don't recall. I wasn't keeping track of hours.
Now, Ms. Garcia, you saw the final order of dismissal there, correct?
Yes,
What's the date on that document?
this February 2nd, 2026.
Now, Ms. Garcia, you just right earlier that you reported the expenditures made to Mr. Williams' law firm in January 2026, is that correct?
January,
Okay, and that is in fact before this order entered upon, correct?
yes.
No further questions?
Teriyaki, you have other witnesses you're gonna call?
Yes, Mr. Chairman. Complainant calls Mr. Jacob Candelaria.
Can we have a short break after the break?
Yeah, we can. And, Mr. Teriyaki, you gonna call me for the alphabet?
We don't anticipate doing so now.
Okay. Yeah, it's 3:03, 3:10, we'll be back if we.
want to confirm that there is still a forum present.
Yeah.
We have 4.
Okay. Mr. Chairman, complainant calls Mr. Jacob Candelaria to the stand. Present.
And I do, I swear or affirm that the testimony you're about to give is true and accurate to the best of your knowledge under penalty of perjury under the state of New Mexico law.
I do.
Thank you.
Mr. Candelaria, can you introduce yourself?
Good afternoon. My name is Jacob Candelaria. I'm an attorney in private practice and resident of the city of Albuquerque.
Mr. Candelaria, you're also the complainant in this matter, is that correct?
That is correct.
And now, Mr. Candelaria, I understand that you were the attorney of record that filed a lawsuit challenging the nominating petition for sufficiency of against this Garcia. Is that correct?
Correct.
Okay. Did you in fact file a lawsuit challenging those nominating petitions?
I did. We filed suits in early September of 2025 challenging the nominating petition submitted by Teresa Garcia, alleging she did not have enough valid signatures to appear on the ballot for City Council District 3. At the same time, we also filed a companion lawsuit against then candidate, now City Councilor Tejas, making the same allegations for different set of clients. The two cases, however, involved a common question of law, which, boiling it down, was whether or not the state primary election law controls of the city charter in terms of what signatures will be counted, what signatures are considered valid or invalid.
Now, Mr. Candelaria, as part of that representation, did you have to attend any hearings?
I did.
Okay, can you tell me about that? What was the hearing at the time?
Well, we had both cases, the Tejas matter and the Garcia matter, were noticed on September the 12th, beginning in the morning, I believe around 9 o'clock. The judge first entertained motions dealing with the legal issue that I just addressed for you of whether or not the judge counts signatures according to the city charter, or the election code of City of Albuquerque, or whether or not he, Judge Allison, had to follow the primary election law. And there were indeed some conflicts, some signatures under the city charter that should not be counted, signatures under the election code of Albuquerque that should not be counted, whereas the primary election code would say those would count. We had many hours of argument on that motion. The judge ruled that the primary election law would govern, and it was on that basis that I elected to voluntarily dismiss Ms. Garcia's claim at that time. And the remainder of the day was spent going through the merits of our challenge against Ms. Tejas, and the judge ultimately entered a ruling on the merits as to that case, but dismissed Ms. Garcia's case at my request that same day before we were done with the hearing.
And Mr. Candelaria, I just want to highlight a portion of that testimony there. So I want to understand that you had a hearing in this matter against Stephanie Garcia that resulted in a dismissal of the case?
Against Teresa Garcia? Yes.
Okay. Was that a dismissal with prejudice, without prejudice?
It was with prejudice.
And what does with prejudice mean?
In my understanding, it means it is dead. It does not come back for any reason. It is gone.
And Mr. Candelaria, did you ever file a notice of appeal after the September 12th hearing when the case was dismissed against Ms. Garcia?
No, I would have had no basis to do so. I had voluntarily dismissed the case. My understanding of the primary election code that governs these appeals is they provide for a very expedited notice of appeal timeline. I believe it's 10 days. Actually, you have to appeal the entry of a final order in one of these election challenges in district court. I did not file that notice of appeal in Ms. Garcia's case. I did, however, file a notice of appeal in the Stephanie Tejas case. That case was, I filed then a certificate of counsel, as well as other filings in the Tejas matter. There was briefing, and then the Supreme Court ultimately denied the appeal and left Ms. Tejas on the ballot.
Mr. Candelaria, following dismissal of prejudice of the complaint against Ms. Garcia, in your mind, was the case still alive at that point, dead? How would you characterize it?
It was dead.
Okay. Now, Mr. Candelaria, have you represented candidates in past ballot access challenges before?
Yes, I have.
Okay. Can you tell us a little bit more about those cases?
I have represented both challengers as well as candidates, so I understand the emotions run high on both sides of the V. No one likes them, but they are really the only way that our election system puts a check on nominating petitions, on declarations of candidacy. You know, the filing officers receive those documents. If they're facially valid, they're approved, and both the city system and state system depend upon voters to file these types of challenges. So I've represented candidates who, most recently, a young man who was running for the state house, we had a full evidentiary hearing on whether or not to kick him off the ballot. And I said I've represented people who are seeking people to be removed from the ballot. I've done both. I do both.
In those cases that you have just discussed, did you charge for your legal services?
Yes, I did.
Okay. And did you invoice your clients for legal services?
Yes, I did. And as an attorney, my common practice is to ensure that I am submitting invoices so that my client, the candidate, can make reporting of my services and expenditures on me consistent with whatever applicable deadlines and timelines exist for the reporting of campaign expenditures.
Mr. Candelaria, can you tell us a little bit more about that? I mean, how have you as an attorney been able to work with your clients to ensure that they disclose these expenditures within the campaign reporting schedule?
So it's not a difficult or mystifying process at all, right? Whether it's the city election code or the state primary election law and the rules enacting that law by the Secretary of State or the city clerk in this instance, that'll give you your timeline. You need to file a report on X date. That report looks back on all the expenditures and all the contributions for that period. You just look at that and tell your client when you're being retained, okay, as a lawyer, we need to make sure we're making these reports along the way because you have a continuous reporting obligation. It's what I've done in every single one of these cases I've had. And again, it's just not hard to do. You look at what the timeline is. You say, okay, I'm going to invoice you. You may or may not make payment, but that's what we do.
I'm going to object to this line of questioning. What Mr. Candelaria does or doesn't do in billing his clients doesn't have anything to do with what Ms. Garcia's case. You know, what was billed to Ms. Garcia and why and when.
Mr. Chairman, we would say that the objections on time, the witness has already testified as to.
Okay.
We can move on. Yeah. Now, Mr. Candelaria, at some point, did you file an ethics complaint against Ms. Garcia?
I did. I filed an initial complaint under the city's ethics and campaign practices ordinance with this board in early December. That was returned to us by staff because I think I had, as a lawyer, I'm used to notice pleading, and this board actually has what we have code pleading. You need to cite like the particular chapter and verse. I believe there was an error in my citation, so I then had to follow that up with the filing of a amended complaint, and I believe that was filed on or about December the 15th, the amended complaint. Okay. Of 2025, sorry, December 15th, 2025.
Now, Mr. Candelaria, you heard testimony from Ms. Garcia that she disclosed expenditures to Mr. Ring's law firm in January of 2026. Is that correct?
Yes.
Okay. Was that was your ethics complaint before or after that disclosure?
I filed my ethics complaints, looks like just about under 3 weeks before she made her first disclosure of this expenditure.
And Mr. Candelaria, you had a chance to see the order that was entered dismissing that case?
Correct.
And that was but after Ms. Garcia reported the expenditures?
Yes, as I understand it, she first reported Mr. Ring's expenditures on Mr. Ring on January the 8th of 26. The final order memorializing the court's verbal order at the hearing came, I believe, early February of 2026. So a couple of weeks, 3 weeks maybe after she filed the first disclosure.
Mr. Candelaria, you testified earlier that the lawsuit against Ms. Paez continued on after the September 12th hearing. Is that correct?
Correct. There was a notice of appeal filed, then there was briefing, and then ultimately an order of the Supreme Court denying the appeal and upholding the district court.
When did that order get entered, if you recall?
I don't recall the specific date, but as I seem to recall that it was before Halloween. This scope of work that my firm did for clients on these two particular races, I remember distinctly being done by Halloween because I joked that I should dress up as like some kind of like demented lawyer kind of thing. I don't know. It stands out in my mind. By that point, we had been done.
Mr. Candelaria, correct me if I'm wrong, but Mr. Ring, was also providing legal services to Ms. Tellez in that lawsuit as well. Is that correct?
Correct. There was one lawyer handling both lawsuits.
Permission to approach Mr. Chairman? Okay. Mr. Candelaria, I'm handing you what's been marked as complainant's exhibit. I'm not entirely sure what number we're at right now. At 5?
5.
Do you recognize this document?
Yes, this is a 10th campaign disclosure statement filed by Stephanie Tellez on November the 3rd of 2025. I personally found this report on the city of Albuquerque's campaign finance reporting system and was able to download this report. I made no changes to it.
So, Mr. Candelaria, is this document the same, substantially the same condition as when you downloaded it from the city of Albuquerque's website?
Yes, it is.
Mr. Chairman, move admission of exhibit 5.
I'm going to object to the entry to this exhibit. Its acceptance. This document was provided this past Friday. And here we are on Monday. And basically, we don't have. He can purport that he downloaded something and then it says what it says, but there's no way to parse the expenditure as related to my services or the services of anyone else. Yeah, I saw it. You go ahead and look on the page. But
I'm gonna admit it. Like you see that
we can have Stephanie Tellez come and testify as to what that is.
it's a foundation, Mr. Candelaria said he downloaded, he's a member of the bar, he's appearing as a witness, but, we're gonna give the courtesy of taking his testimony as the focus, that it's an accurate copy of what he downloaded, and, we're gonna admit it, and then as to what purpose, what it, tribunal can see where this is going, but, let's, we can go down that path, so. Do we have copies of that one? No, I don't think we do.
I don't think we do.
I didn't know
No.
this was a-
Yeah, my apologies. I don't think I have that one.
Okay.
Um,
And, well, you will keep in mind that, they did not, they did not notice it in the previous way. We just abandoned by that, but.
Mr. Chairman, I was simply said we were contacted by Mr. Rocha on Friday of last week, asking for any other documents that need to be included in the binders. We responded with this document, so from our perspective, we were kind
I
of.
understand now, I mean, you exhibit listed here like a month ago. We'll let it come in for now. We'll let it come in and, I'll proceed.
Mr. Candelaria, what was the date that this report was filed? Lisa?
Pursuant to the record that I downloaded, it reports that it was filed on 11/3/2025.
Mr. Candelaria, do you see anywhere on that report where Ms. Tellez is reporting the legal services, expenditure for legal services to Mr. Ring or his law firm, McCoy Law?
Yes, on page 5 of 6, on the second box down, there in the itemization of expenditure section.
As to the form of the question, what he's asking whether it discloses my legal services, and there's nothing that's been offered for that.
I mean, Mr. Chairman, one, we would say that objections are timely, and two, there is something in the document.
So, it's a formal question, you don't believe these.
Well, he hasn't, there hasn't been, it presumes facts that aren't in evidence yet, because we don't know what that's what it is, I have to research that.
We've heard though that you represent the client, right?
Correct?
If that's an evidence.
Yes.
And so, Mr. Candelaria, is there an entry on there for a payment to Mr. Ring's law firm?
Yes, there is.
Is that the question?
Okay, if the board will look at the exhibit though, it doesn't say my law firm.
Okay.
Mr. Chairman, it definitely says Equitas Law of New Mexico, 5901, Wyoming Boulevard Northeast, Albuquerque, New Mexico, 87109. Employer, David Zimmerman Ring IV, occupation unknown. So it does clearly reference his law firm. And to your question, Mr. Chairman, the record reflects a payment from Ms. Tejas to Mr. Ring's law firm of $1,002.50 on October 27th, 2025 for a description of legal defense.
What page are we on?
Page 5 of 6, sir, towards the top.
During how many of them can do?
Okay,
What's the objection?
okay, well, I didn't see, the, I got this exhibit this morning, and I didn't see the part where it says on cost line limits. So, the reason why I'm objecting is I have no record of a payment in the amount of $1,002.50. I would have to look into that. So,
You're not as a witness right now.
I understand.
The document speaks for itself and will, continue this for, I think.
Mr. Candelario, just one final question for you. Absent your ethics complaint against Ms. Garcia, would we have ever known that she'd expended these funds to Mr. Ring in support of the legal defense?
I have no idea.
He's not objecting, that's speculation.
No, I think the question is asking if I have a basis
You
to
have any
believe that.
reason, Mr. Candelario, that this won't be speculation?
Yeah, I do, because I can be asked of whether or not I have any personal knowledge that would lead me to believe that but for the filing of this complaint, the respondent would ever have actually complied with the law. I do not have any independent factual basis that absent my filing of this complaint, the respondent would have ever complied with her legal obligations. That's the basis of my knowledge.
You don't know of any reason why she would.
No, I have no idea why.
You don't know that your complaint is going to.
All I know is that when we look at the timeline, my complaint comes and then she reports. The timeline is what I rely upon.
No further questions, Mr. Chairman.
We probably heard the question more clearly.
Okay.
No further questions, Mr. Chairman.
Mr. Ring.
I just have a few, in referencing your timeline, do you know when your complaint was conveyed to Ms. Garcia?
I sent it to a process server the day we filed it. I believe it was served the next day or the day after. We are required under the rule to expedite service in these cases.
I'm sorry, it should have been more clear. Your complaint in this matter, as the complaint, are you aware of when Ms. Garcia was apprised of your filing for the?
Sometime after December 15th, but I do not know when.
Okay. And you're also aware of when you're saying that you're relying on the timeline. You're relying on the invoice that was emailed to her on December 8th, correct?
I don't know what you're referencing.
Okay. So I'm referencing our exhibit, respondent's exhibit. B, no, B. Respondent's exhibit B. This is, I can get it from you already from your own copy. Okay, would you please read the date of the invoice that you're relying on the timeline?
Well, this document purports to be dated 12/18/2025. I have no way of knowing if that's true.
Okay. So, you had testified that you did not know when she was apprised of your complaint in this matter, correct?
The exact date? No, I don't.
Okay, very well. Okay, looking at the Respondents Exhibit D. Are you familiar with this document?
Yes,
When did you receive this document?
I don't recall.
Okay. Did you receive this document?
And as counsel of record in the case, typically counsel would have worked and submitted this order sometime prior to February the 2nd, 2026. I just don't recall off the top of my head when that happened. You were the lawyer in that case, so I imagine you could let us know.
Do you recall when the order was prepared?
No, I don't. I would look to you to confirm for us that information. I don't recall.
Okay. Fine. But was the order prepared after the hearing? Would the order have been prepared and submitted after the hearing?
Typically, my practice is the local rule says that orders must be completed and submitted within 14 days of a hearing. So until I'm shown something different, my expectation is that we would have complied with that rule and submitted this form of order before the end of September.
Okay.
It's up to the judge what they do with it then, but in terms of signing off on it, the local rule says 14 days in the second judicial district.
Okay. You disagree with the form of the order in any way?
No, it's accurate that this case was dismissed in open court on September 12th, 2025.
Can you read the rest of it though,
Do you need me to?
please?
Is there some reason you cannot read it?
Mr. Candelaria, we understand, just.
It's this one sentence.
Which I'm just curious what he wants me to read.
You said the part.
Excuse me, Mr. Mr. Candelaria, your witness, just. This is a standard question, which we believe.
Sure. May I be asked what I'm supposed to read?
Just read the entire sentence, please, first sentence.
I'll read the whole thing. It's very short. Final order of dismissal. This matter is before the court upon plaintiff's notice of voluntary dismissal made in open court on September 12, 2025. Based upon the court's decision in Gonzalez v. Kavanaugh, Second Judicial District Court case number D202 CD 2025-07766, that refers to the Tejas matter I've been talking about. Order then goes on to state, quote, it is therefore ordered a judge and decreed that the complaint in this matter is hereby dismissed. This is a final order. Joshua A. Allison, District Court Judge.
So do you, in your testimony, you said that the decision of the Supreme Court in Gonzalez versus Kavanaugh came down in, we said around Halloween. Is that what the testimony was?
My recollection is by the time we got to Halloween, this was all over in all cases. The appeal, everything.
Okay. Would you? Okay, and assuming that's the case, why would the court, in case involving Teresa Garcia, wait until the decision, the mandate was received from the court in the case involving Stephanie Davis before issuing the final order of dismissal?
Mr. Chairman, objection on the grounds of false speculation from the witness.
Well, he was at the hearing with the judge.
Mr. Chairman,
What he'd be doing.
counsel is asking for Mr. Candelaria to speculate on the reasons why the court may or may not have done something.
Do you know the reasons why, Mr. Candelaria?
I'm a simple lawyer. I don't question why judges do what they do.
Okay. Do you recall, what the basis of the voluntary dismissal was made in court was?
Yes, we do.
Okay, what was it?
So there were many signatures that Ms. Garcia and Ms. Tejas submitted to the city clerk that, according to the city election code and the city charter, are not valid, should not be counted. State primary election law, however, at the time there was a conflict, and state law is saying, no, you should actually count what the local law is saying as invalid, as indeed valid. And that was the threshold legal question the judge had to ask and answer. Once the judge ruled a couple hours, 2-3 hours into the hearing, that the state primary election law controls what signatures the district court will consider valid or invalid, it became clear at that point that only applying the state law, Ms. Garcia had enough valid signatures, whereas if the court had applied the local requirements, she would not have, in my view. So it was really to save everyone time and just cut to the point, you know, and save the judge and parties time. I just thought it was the right thing to do, to just, you don't have the evidence, you just gotta fold it and move on.
Well, the matter, the voluntary dismissal that was made, was it conditioned upon the court's ruling in, Tejas versus, in the Tejas case, Stephanie Tejas?
No, it was not. We did not appeal the voluntary dismissal.
I'm not asking whether you did appeal, but if that was the voluntary dismissal based on the court's rulings in the Tejas.
I can ask them answer.
I didn't get an answer.
I'm sure you will.
Okay.
I'm trying to think of it.
No further questions. And,
Okay, that was your, no redirect, Mr. Chairman. Okay, and that was your, and that's our final list. We rest. Okay, Mr. Rain.
I'm gonna go ahead and waive direct, Torres Garcia. I think we covered everything, on cross. And he's already done it direct, so I think that we could just move forward.
Mr. Rain, the chair has questions for you.
Sure.
So what do you think to do? Harold?
Can you sit? Oh, okay, here we go.
Mr. Ring, about how many,
Oh, Mr. Chairman, you have to.
well, I was right, I get, I swore to Jacob. You're looking at that. Mr. Ring, do you swear and affirm that the testimony you're about to give is true and accurate to the best of your knowledge and independent of perjury or loss of state in Mexico?
I do, Mr. Chair, and honorable to be numbered.
Thank you, thank you. Is this your first case, with, a petition challenge in the election, Ms. Garcia's, and Ms. Tejas'?
No, I've been doing them since, 2014.
Rough number of cases you've done?
More than a dozen, less than 15.
Is this hybrid cap fee, do you use that in the majority of cases where you're, with petition challenges?
I do, the only, in fact, it's a standard agreement for election cases. It's, the difference could be, flat fee agreements are allowed by the state bar. I was paying more attention to the rules of professional conduct. I didn't anticipate the rules of the Board of Ethics of Campaign Finance in drafting these agreements, but, I think we still comply. The only difference between, say, another candidate, possibly Stephanie Tejas and Torres Garcia, is whether the flat fee is paid up front or not. Sometimes it is paid up front, and that is something that it can be done. But most of the time it is done as it is earned, and the rules of professional conduct, particularly the commentary in cases on 16-105 and 16-115, basically say that I can't claim any of that fee until the entire representation is complete. So it has to sit in a trust account. Can't be moved to operating.
If you've done a retainer, in this case, you get a retainer, so that's not even a question.
Correct. In this case, if the fee is earned, it can be deposited into operating and used by the user. And but both scenarios are contemplated and allowed.
Is it standard for your, representation agreements, election challenges not to include anything about when the invoice will be, issued and when the payment's expected?
Yeah, the agreements are silent as to when payment is expected, but it's expected when the representation is on the platform. This was also, this fee agreement wasn't developed during, Mr. Watson's tenure. This was developed during Ms. Buick's tenure, and this was the way, in consultations with the city attorney's office and the city clerk at the time, this is the way, these are done. I was told.
In any event, the question is, if this is the same as the other agreements you've had with clients, in terms of being silent as to when the invoice is generated and the payments expected.
Yes, I'm sorry, I make it clear, I need to say it somewhere in
And, uh, and before you went up on your own or being the witness, we started to talk about, the, reported pay as expense of, fuel law firm. And the question is, do you recall invoicing the status for the work in the parallel case?
No, I didn't feel it was appropriate to invoice her for, work that was done in the Stephanie Days case. Honestly, this question came up several times because depending on which case gets a hearing first and which, I mean, if they involve identical issues. So, you know, the question is, how much can you bill one client for the same legal research in another client's case?
But Stephanie Davis was your client.
Yes, she was. She was.
And
And I confirmed, by the way, that, she did, give me a payment of $1,000. It was not requested. She did that of her own volition.
they did not invoice her.
I did not.
And
But I love it when my clients give me payments unsolicited. I think it was probably because of the successful outcome of her case. I know that, she was billed differently, like she was also billed for the appeal, whereas Teresa Garcia was not.
she's not the subject of a complaint before us. I don't want to get too much of that.
Yes.
Any questions from members? Now it's the witnesses, there's no witness questions, so. Question. Yeah. Yeah. So that 7, file, you signed that, right? You attested the contents.
Yes, after every report, we have to do like an electronic signature. That's good.
You describe what process you went through prior to making that attestation.
I submitted all of, like my receipts and expenditures and also like my ACT donations. So I kept all my receipts, everything that I, spent on my Newsenda account, which is my funding account.
Were you the person that actually filled out the report?
Myself and, my treasurer, Sylvia, Hunter.
During that process, what if any consideration you give for considering accounting for the representation by Mr. Ray?
Can you rephrase that?
Yeah, did you think about when you were filling that out, how to account for your relationship with Mr. Ray?
I will account for it?
Yeah, so you're going through this process, right?
Yeah.
You have a bill on there. You enter into a professional service.
Mr. Ring, he's performed services for you during the relevant time period. How did you consider that issue going out the campaign finance?
I didn't have the invoice, so I did not put it into the campaign financial.
So was your criteria for including content on that program not going to be voiced?
Correct, yes.
Did you include any other expenditures or expectations of payment, aside from anything, where you had needs?
I put everything into my campaign finance report, if I had a receipt, invoice, et cetera, to reflect what came in or what went out.
That's all I had. Thank you.
Yes, sir.
Let's go to closing. And if there are questions for the council, we'll take it out.
How much time would you like, Chair?
Sir, I'll be, I think we have 6 minutes for closing. You want to save some of the rebuttal?
Yes, Mr. Chairman, can I reserve 90 seconds for rebuttal?
Okay. 1 minute, there. Welcome.
Ready?
Let's do it.
Thank you. So, Mr. Chairman, members of the committee, ultimately, this case is still pretty simple there. So, at the end of the day, there's no question that the rules of the election code are to pretty clearly define that an expenditure includes when consideration is received from the candidate there too, involved there. It's also explicitly clear about the reporting schedule that has to happen for these expenditures there too. And it's very clear that legal services are in fact considered an expenditure there too. And the client must report that either the earlier when payments made and consideration received. Now, there's no testimony at all that was disputed that consideration was in fact exchanged and received in September of 2025. Ms. Garcia testified, yes, indeed, I signed this agreement retaining the legal services of Mr. Ring, and she understood that she was incurring an enforceable promise to in fact pay for those legal services. Mr. Ring did in fact render those legal services to quite the benefit for Ms. Garcia, resulting in the case filed against her being dismissed on September 12th there. Now, that dismissal was with prejudice. You heard testimony from Mr. Candelaria establishing so that it was clearly dismissed within court with prejudice there. Ms. Garcia was present for that entire hearing there too. You also heard testimony that there was no appeal filed following the dismissal of that case, and in fact, Mr. Candelaria's word that case was dead overall. Now, Ms. Garcia claims that there was no reporting that needed to be done of these expenditures until the case was finished and done. And she points to the order of dismissal entered by the court in that as the kind of final moment there. However, that's just clearly disingenuous in this matter there too, because Ms. Garcia actually reported those expenditures to Mr. Ring's law firm in January of 2026, about a month before the order that was finally dismissing that case there too. You also heard testimony there too that Ms. Tejas was under the exact same agreement and was able to report in November of 2025 there. In fact, really, I mean, if you look at the timeline here, it's that Mr. Candelaria ultimately filed an amended complaint alleging these violations of the ethics rules, and it's only after that that we see that Ms. Garcia does in fact report those expenditures to Mr. Ring's law firm. And once again, not before there's an order entered by the court or whatnot there. So, and so ultimately, Mr. Chairman and members of the board, it seems pretty clear here and there too that the rules are very explicit about reporting expenditures in a timely fashion there too. Ms. Garcia clearly received a benefit from the legal services there too. The obligation was to report those on that 7th campaign reporting deadline there. Mr. Chairman, members of the board, ultimately this is to be able to provide the voters with some transparency there, to be able to understand what expenditures are being made from the campaign, who are they paying for these legal defenses there too. And if those expenditures are not reported until after the election there too, despite the benefit of those services all being incurred months prior, it ultimately obscures a lot of the transparency for the voters there too. And honestly, it opens up the door that any client for public office could say, please don't invoice me until after the election there too, to try to circumvent the reporting requirements within the rules. And once again, just looking at the language of the rules, it's explicitly clear about it's got to be reported earlier of the consideration or payment when received there too. And so ultimately, Mr. Chairman and members of the board, we think the timeline's pretty clear there too. Ms. Garcia did not follow that schedule until after the ethics complaint was filed there too. And now she's here trying to say it was just an impossible task or, She didn't expect to have to report those, but she did voice that. So we ultimately, believe that there enough evidence has been asserted here to show that Ms. Garcia did in fact violate, the sections of the Elections Code and would seek both a censure and or fines imposed by the board pursuant to the powers under the act.
Any questions for Mr. Ariaki?
Okay. So let's assume that we find a violation that the way what the appropriate sanction is. I haven't seen a lot of evidence before this was an intentional act by Ms. Garcia. And I think I also struggle, I acknowledge the importance of adherence to these rules, but it's hard to see how this particular infraction contributed in a significant way to undermining the system that we enforce. And so if you could just address those 2 points, I would appreciate it.
Thank you. Yeah, so Mr. Gunner, first we would say that ultimately the rules don't have taken into account all the intentionality of the candidate there too. At the end of the day, it's a pretty black letter law that.
So let me just, I don't want to be rude, but, so we can find a violation and presumably not impose a sanction, right? So I'm not asking you to argue whether or not there's a violation. We've done that enough. My question to you is based on other criteria that we might consider to determine whether or not to ask her to pay money. You know, what's supposed.
Yeah, I mean, Mr. Gunner, hopefully I would say that candidates for public office need to be held to a very high standard there too. So even if there's some sympathetic reasons for why potentially reporting wasn't done properly, at the end of the day, I think it's more about the voters of the city of Albuquerque are having a right to understand when these are made there too. In terms of like a value of a fine or what that would look like, I mean, ultimately that's within discretion of the board for the expertise of you all. No, I'm sorry, Mr. Gunner. What was your second question?
I'm sort of trying to weigh with, right? Like we all understand the importance of adherence to the rules. We want candidates to get the message that all the rules and disclosures are vitally important. But in this specific instance, we're not alleging that Ms. Garcia, you know, hid $10,000 or wanted $10,000 through her campaign effectively by not reporting it. We're talking about one discrete transaction where there is a plausible explanation, right? Namely that she didn't get the invoice the next day and then appear on her campaign finance. So what I'm getting at is, you know, where does this sort of rate on the continuum of seriousness, right?
Well, Mr. Gunner, we would say that the voters not being able to review this information prior to the primary election is pretty important too. At the end of the day, free and fair elections that are transparent are among the most important, you know, duties and things that government should uphold here there too. And once again, it sets a bad precedent that any candidate for public office could just use these invoices after the fact there too, to obscure the ball from the voters there too. So I would openly say it opens the door and it's a slippery slope there too. So it's kind of, you know, getting done on.
On the same lines, we didn't write the charter. We're here to enforce it, so we didn't make the policy, but it helps us to understand what we think the policy is directed about. And would you agree that there's a much higher public interest in having timely reporting of contributions in an election versus, say, expenditures?
Yeah, we would say that they're pretty equal in importance though.
Really?
I guess we wouldn't determine.
And then, and in this particular case, would you agree that the fact that Ms. Garcia was employing Mr. Ring was public knowledge? The amount certainly was not, but it wasn't concealed. The lack of reporting did not conceal the information public that the Mr. Ring's firm was representing.
Mr. Chair,
responding, correct?
Mr. Chairman, we would say that it did prevent, it did scare up in the public there too, because ultimately voters, you know, if they understand that there's gonna be these expenditure reports filed by the candidates there, that's what, you know, and they would have a right to know how much it's spent, and that's where the voters are gonna be looking there too, and the average voter would not think to be able to go look up research in Mexico for representation here. If the purpose of these campaign expenditure reports are to provide that detail to the voter there too, absent that, I don't think we can assume that the voters know about that.
Any other questions for Mr. Cardiac or for
Yes, this matter, I think that we were able to distill this matter down to its, pretty much the central question of when the expenditure arises, when consideration arises, especially for the departments and its forceful promise to make the payment. I would submit to the committee that the election code is pretty much silent on the issue we're discussing. The code, however, is where I saw that this could be interpreted poorly against Ms. Garcia. And part of that is just how there's a few principles of what the committee can consider, or the board can consider as it makes this decision. One is there isn't an intent requirement in this Part 5 expenditures. And I know in criminal law, when there isn't an intent requirement, we assume a general intent, for instance, to violate. Ms. Garcia has testified that she didn't, you know, do anything to address this because it never came up. She's also testified that she was waiting on the bill, which is what a layman candidate would do. So in many cases, when you have codes, like whether it's a health code or property code or zoning, it's usually, the aim is typically to correct the condition rather than to punish the actor, if you will. We call that compliance over culpability. So I'm not aware of, and this Garcia certainly isn't aware of any interpretation of this code and this issue. I know, I mean, you heard that this is what I do with my agreement. I did want to kind of go into that because the committee's going to have, the board is going to have to ask itself just how much it wants to get into regulating attorney professional services. Because its jurisdiction is over the candidates, and you can get candidates to do certain things based on what they know from reading this code and from doing their compliance statements. I submit to this committee that Ms. Garcia did everything that a concerned candidate would do in filing the disclosures. This is, you know, a very, you know, kind of obtuse legal issue for a candidate without more guidance in the code. I think that we also heard testimony that she requested my invoice after the runoff, and that's why it was Christian. We heard testimony from Mr. Candelaria that he doesn't know when we were apprised of his complaints. We weren't apprised of his original complaint that was rejected. We were apprised of the amended complaint, whose correspondence with this committee, which is in the record. Like I noted, so I forget what the board calls it. It's a notice that there's a complaint. And so by that time, she had already been emailed an invoice because she requested it at the end of the election. Even though the final order of dismissal hadn't come through from the district court, we heard testimony that these were two related cases. I mean, what she was billed for is related to in some way what Stephanie Case was billed for. But as far as the final order of dismissal, that was there in February of 2026. The reason why the bill was paid before then is it seemed like by the time the runoff is done effectively, there's no, I mean, Ms. Garcia lost the election. She lost by 71. I believe it was 71. that, this was a close race, but the practical effects of, her, paying the bill or whether there was going to be more complaints to follow that, did come to fruition. This is an ancillary matter that I'm sitting in right now related to this, election petition. So, I took a flat B and Arkansas law is living with that, unfortunately. But I think that, I think that attorney agreements, representation agreements are highly regulated, by the Supreme Court and the rules of professional conduct. Rule 16105 and Rule 16115 place a lot of restrictions on this. There is also, I would cite Henry Montclair, 2016 MSC 023, and Henry Yalkut, Yalkut. That's going to be an older one before the official MSC reporter. That's 143 and 387. And there's a focus on that it be reasonable and when the representation is complete to where the attorney can take it. So I think we're going to get into conflict if this board starts to interpret these election code rules as regulating attorney fee agreements. Obviously, I wouldn't have known to how to structure this fee agreement before this hearing. I don't think Ms. Garcia certainly wouldn't have known to tell me about it. This is something that I believe the board is going to see if it's brought to their attention, repeatedly. So, and I don't think there's any harm in the public.
You're out of time.
Oh, okay. I'm sorry. I thought I had 20 more seconds.
Yeah,
I'm at 6:30.
okay, you're out of time.
Okay.
Okay.
Very well. I'm out of time and out of, thank you.
Very happy.
Thank you, Mr. Chairman. It's quick rebuttal there too. So ultimately, you heard opposing counsel talk a lot about this idea of criminal intent and the standards that come in there too. It's just simply irrelevant. At the end of the day, this is a civil case. There's no intent that's required by the code of the rules. We also heard about how Ms. Garcia, expected an invoice and that was going to trigger the obligation report. That's simply just at odds with what is required by both the code and the rules. At the end of the day, what a candidate expects and what is required by them are simply not the same thing there too. And additionally, not reporting these expenditures in the manner required by the rules, ultimately artificially reports the cash on hand a client can have and gives them an advantage going into an election there too. At the end of the day, a finding that Ms. Garcia violated the reporting requirements there too, it doesn't result in court intrusion into the attorney-client relationship or into regulation of the scope representation agreements. It simply just requires that the candidate abides by the rules that they signed up to follow. Yeah, which was we saw, Ms. Diaz was able to follow like that. And with that, Your Honor, we rest. Thank you.
Mr. Teriyaki, so I think the client testified he's been in court. I don't know.
Sorry, Mr. Chairman.
He doesn't, I know he testified, he doesn't do it this way. When I was attorney, I told monthly. And so say we got an attorney, and pretty standard practice, bill monthly, end of, I provide service in September. I've got an hourly agreement on one of these flat fees or hybrid, right? And I provide some services in September. I represented Garcia and I lost because I'm not as good as you guys are. But anyway, so I generated a bill and it's $2,000. My client reports it on the report that's due October 14th or something, right? And that's all. I think everything's okay. But the thing is, I did some more services for her the first 7 days or the first 10 days of the month. The way you're reading the regs, some consideration you receive consideration, my client received consideration those first 10 days of the month, I'm not, should the attorney, when they're doing a case in this specific, well, issue an invoice for every reporting period, as opposed to your normal monthly cycle? Because that's the only way it's gonna be in compliance, correct?
Mr. Chairman, that seems like that would be, a good approach for attorneys going forward here to ensure that the candidates they represent are in compliance.
And then that's the only way to do compliance. I mean, I could have generated a monthly invoice for September, and if I did any services between, September first and the cutoff date for the report, it wouldn't be in there, even if I hadn't.
Yeah, I wouldn't say it's the only way to be in compliance, but that's best way, and then, yeah, specifically for a lawyer that do election law, invoice monthly there too. And then it's a hypothetical you pose there too. I mean, in that scenario, the candidate can simply report those additional hours in the next reporting period there.
Well, no, they don't. Not according to your interpretation. Your interpretation is that it's, the minute you do a service, it's in, there's no invoice, it's reported.
That's correct.
Okay. So, members of the board, we've done a thing here, and we certainly can go into closed session and discuss what we want to do about this, and what we think. We can also do an open session. Is there a motion to go into closed session, or? I know our council would love us to do it, but it's been with me for a while, you might, pretty agnostic about it. So anybody want to go to close? I'm not hearing it. Do we have any discussion, or we have a motion on this, to dispose of this complaint? Should I make a motion, or, Mr. Chairman? Mr. Kelly?
Before, my colleague makes a motion, what is it that you are, you know what? Let's just, you make the motion.
Just trying to move things along, we need to either deny the complaint or find in favor of the complaint and propose a penalty, so. We can discuss it, but I think it's, we do, yeah. In my experience, Robert's rules can move things along, so a motion. And we'll see where we're at.
Motion. So I move that the board find violation of the disclosure requirements and then issue a light reprimand. By which I mean a letter to respondent that apprises her of the violation, indicates the relevant provisions of the code were violated. Third degree honest.
If there's a second for that, motion.
I'm not prepared to make a second. Can you reference specifically the section, the statute that you're referring to when you outline that process?
Member Kelly, can you turn on your mic, please?
Sorry.
Thank you.
We were talking about the election code, section 4. One and 2. Does that sound right?
I think the point of I would say, I think I looked at section, Article 13, and it doesn't And Article 13 reads that expenditures are reported in the payment. I think the violation is now in the clerk's rule in the Part 5B, which is the expenditures made on the earlier that we payment. Is made or consideration.
That's correct, Mr. Chairman, and also within those rules is the authority for this board to issue a reprimand.
Right, but you would agree that, if we're just looking at the charter, there's not a clear violation, it's only a violation when we look at this definition of the thing.
That's Mr. Chairman, but we think that it's important that you have to incorporate also the rules that are
Right.
promulgated according to the charter.
They work together, but the charter itself just says expenditures reported in payments. And then this rule elaborates on that to pick up situations where there's a transaction going on and there hasn't been a payment.
Yeah, we don't dispute the plain language of what the charter rules.
Yeah, I think I want the, the motion before the, 1 and 2, incorporating by reference the definition of expenditure in that source.
Okay, that's the first rule, part 5. That's the motion. There's a second on that one.
Did you state the motion?
I'll. Okay. The, motion is to find that the charter as modified by the clerk's rules, and the specific sites, hopefully some of them running down, was violated by the candidate, Ms. Garcia, and then to impose a light reprimand, which is to apprise her of the requirements of the code and regulation and advise her that the campaigns again. I'm gonna second it and then offer the friendly amendment to clarify that the evidence shows the violation was not willful. That was not willful. That's the motion. We either take a substitute motion or vote this one and then we don't get, we need. We need the majority of present rules for to. I think that form would be together, correct? That's my thing. Okay, so we get 3. We have an order. So, call the roll, please, Mr. Rachel.
Member Cuniff,
Yes.
Member King, Member Kelly,
I'm sorry, Mr. Chairman, can you restate the motion that we're voting on?
The motion is to issue a decision of this body finding that a violation occurred, with specific reference to the places in the charter and the rules that require disclosure of expenditures, basically when they are occurred. And to find that the violation was not willful and to send a letter to the respondent that she did violate the rules, that's not quite as willful, but that she's required to, comply with them. She should be counted with them. Correct? Yeah. And we should get a court report. So that's the motion that's pending. I will entertain discussion, and if there's no discussion, I will take.
I have a hard time voting that the, clerk, I'm sorry, say your name again.
Teresa Garcia. Teresa Garcia.
Committed any sort of knowing violation. No evidence of a knowing violation. She was learning, she was taking law, litigation 101 with a lawyer. That's far away from knowing violation.
With Mr. Kelly, I agree, I said not willful, but I would support an amendment to motion to say it was neither willful nor knowing. But it was a violation. I did not take this afternoon to understand exactly what the rules require, but it's, so I would say it is a violation, I think. But I would agree that we could say not knowing. Would you agree, Mr. Bennett, or?
Yeah, I think that's a harder call.
Okay.
Because, we don't have like a scientific requirement built in here. But, typically, you're all about knowing that there is going to be some scientific quality, but also mean not taking the steps necessary to adequately advise yourself what the requirements are. And so, from that low simplification.
Okay, so Mr. Phillips willing to go to not willing, if there's some obligation, be educated, consult with the attorney. Let's vote it this way, and if we don't get free for this, I'll go for to go. Call the roll, please.
Member Kunev,
Fine.
member King,
I would say no.
member Kelly,
No,
member Selvin, Chair Marks.
Abstain. Substitute motion, Mr. Kelly. The motion.
no, I think that's, your job.
Okay, Chair makes a motion. We find that a violation has occurred. That the rule requires expenditures to be reported when incurred at the next reporting period. That the department violated that, but the violation was neither willing nor with knowledge. That she was violated, that she might possibly be violating it. And it was a caution to comply with this requirement, should she.
Mr. Chairman, at the risk of taking this longer than the word violation bothers me. The conduct can be inconsistent with the law that may have just dried on the books 4 weeks earlier. But that doesn't, she hasn't committed a violation. Well, she may have committed a violation, is what I'm saying, but it certainly wasn't known.
So, the second for my motion. So violation occurred, but it was neither willing nor with knowledge that she was. That she was violating the law.
I agree with that.
We could do that. The violation was not willing, unintentional, and not. That's, Mr. Kelly said he seconded it. That's what I heard.
What about?
What? Oh, when we were out before? No, just now, you said you agree with that, that's a second. I'm not following. Okay, I made a motion. You said you agree with that something. Yeah, that's fine, sir. Mr. Rocha?
Member Cunis?
Oh.
Member King?
Yeah.
Member Kelly?
Yes.
Member Selvin? Chair Marks?
Yes.
Yes.
4-1.
Okay, I will let you know order. I want to thank the party, which was this, Mr. Kanawaki and Mr. Candelaria. I think this is beneficial. There is, at least in the minds of the people are here, the reading of the regulation is the only, it's the only possible reading, but it was not all that clear initially, and I think this will be good guidance. I think the park may want to consider, this scenario in his rules. I'm not sure it's the best way to do it, but you're correct, this is the way it should be done, so until the rules are changed, I think this is the way it's gonna have to be done. I agree with Mr. Kenneth on a lot of this, that, you know, I said earlier, I think when we started this, I want to say my concern was what Mr. Candelaria brought to us initially, which is it appeared to be an in-kind that had not been disclosed, and that to me is serious. That's a contribution, and I think the public wants to know about those. I think the public wants to know on the expenditure side that candidates are not spending their money on hairdressers and you know, things that are not permitted under the code. They're less concerned with who they pay as long as they're and when they pay. But the rules are the rules. So thank you for bringing it to us, and thank you for putting on a good hearing.
Thank you, Chairman, for your time and for the members of the board.
And Mr. Maestas, we didn't get you on the record, but we're going to. You assisted your partner there, so.
He was essential to the
You're
presentation.
essential. Board members want to say anything else? Thank you. Thank you.
Thank you, Mr. Chairman, board members.
Thank you.
Thank you for your time and your grace.
Good to see you too.
Make a motion to adjourn. Second. All in favor? Aye. Opposed? None opposed? What's that?
Yeah, hey, I have yeah, it's good to see you. Absolutely.
Okay.